predsjedatelj.
Časni sude.
Your Honors, before I continue, I wish to apologize to the trial chamber and the OTP, and of course the interpreters. This was absolutely my mistake, because I was too fast. What Ms. Corner said was recorded in this transcript is not at all what I wanted to say. We discussed this during the break, and I will provide an explanation once I conclude my closing statements, both to the trial chamber and Ms. Corner. I will tell you what I had in mind, and I will give you the necessary references. But in any case, I wish to apologize now, both to the trial chamber and the OTP, because of this misunderstanding. Thank you.
Gospodo časni sude.
Your Honors, in view of the issue of the criminal liability of the accused under JCE, that is to say the joint criminal enterprise, the defense deals with these issues in paragraphs 636 through 651 and 664 through 670 of our final brief.
Tužiočev završni podnesak.
In the prosecution final brief, in paragraphs 601 through 607, the prosecution deals with the claim that Stanišić contributed to the common plan. We state our arguments in paragraph
Izneta.
The Council, please repeat the number of paragraphs. The paragraphs are 27 through 43 of our final brief. The prosecution claimed that Stanišić allegedly provided crucial information from his position in the Sarajevo SUP. There is no reference what information they have in mind. No evidence on any information from the Sarajevo SUP was ever presented. Therefore, this claim has no foundation whatsoever. It is certainly true that the presidency and the president of Republika Srpska could have information from a much higher level, the Ministry of the Interior, such as Žepinić or Mandić, therefore a higher positioned official than Mićo Stanišić. In paragraph 602 of the prosecution final brief, there is a claim that Mićo Stanišić was a member of the SDS, and then that he was supported by Karadžić when he was under investigation for providing weapons to the SJB, Pale and Ilidža. The reference for these claims are to intercepts of telephone conversations between Mandić and Karadžić, in which Mandić provides information that Mandić informs Karadžić in one part that the investigation against Mićo Stanišić is unfounded because he was doing everything in accordance with the law as established. Both the defense and Mr. Stanišić personally claim that he never was a member of the SDS. Once again, there is an inconsistency on part of the prosecution here. If I understood well, Ms. Corner on page 2743 yesterday, when she talked about Župljanin, she said the following: there is no direct evidence that he was a member of the SDS, as opposed to Stanišić. It is on page 27343. However, yesterday, during the closing arguments on page 22 of yesterday's transcript, Mr. Hannes said, "We believe that he was a member of the SDS. Even if he was not a member of the SDS, he was certainly a sympathizer, an important supporter, or in other words, Your Honor, there is no evidence that Mićo Stanišić was indeed a member. Therefore, this is quite contrary to the claim made in the final brief. We do not dispute that all parties in Bosnia and Herzegovina supported the members of their ethnic groups and their cadres, but that was because of their nationality rather than because of their political affiliation. After all, the trial chamber is well aware of our position with regard to intercepts as evidence, which we treat in paragraphs of our final briefs. I will now move to page 45.
U paragrafu 605
In paragraph 605, it is claimed that Stanišić had a key role in the ethnic split in the MUP, and Karadžić's words are quoted as evidence for this claim. So, Your Honors, I will ask you to look at paragraph 605 of the prosecution final brief and have a look at Karadžić's words, which, as I claim, are unclear. It is not clear whether they refer to Žepinić or to Stanišić, and it is also a fact that no witness testified about this or commented on it. A checkpoint at Vrace and Grbavica is mentioned there, and it is our position that the claim which the prosecution makes cannot be founded on this. The situation is the same with the prosecution conclusion about the document variants A and B, because there is really no evidence that Mićo Stanišić ever received such a document. The fact that someone wrote several names on the back side of the document, including Stanišić's name, really does not mean that Stanišić did receive this document.
paragraf
The next prosecution subtitle is Stanišić participated in the formation of bodies and forces that implemented the forcible takeover of the municipalities. Paragraph 609 contains the claim that during the first two meetings of the Ministerial Council it was decided to establish an ethnically divided MUP, and this was weeks before the Cotillero plan.
u referen
The references are to the two meetings of the Ministerial Council in which not a single word was spoken about splitting the Ministry of the Interior. I believe that this is another example of misrepresentation and misquotation of evidence. After all, I recently spoke about the fact that discussions about tripartite Bosnia-Herzegovina had been conducted beginning in September 1991 under the auspices of, or rather with the pressure exerted by the international community.
u paragrafu 6
In paragraph 611, of the prosecution final brief, the claim is made that at a subsequent meeting, and then under brackets probably late March, Mićo Stanišić instructed leading Serb members of the Bosnia and Herzegovina MUP to disobey any orders issued by their superiors if they are of Muslim ethnicity and if they were contrary to the interests of the Serbian people. The reference given there is the testimony of witness Šćekić, and the reference given for this claim is transcript page 6528 through 6529. However, this is another instance of misquotation of the contents of the witness's evidence. Namely, the witness discusses this meeting on the following pages of the transcript: 6528 through to 6533, and then 6572 and 6573, and then again answering the questions by the trial chamber on page 6587, and finally on pages 6590 and 6592. Once you read all the relevant sections of the transcript, you can see that his testimony is the following: that the meeting was most probably held in early April, that it was chaired by Dragan Kijac. It was a brief meeting, and Dragan Kijac was the one who informed those present, rather than Mićo Stanišić. The witness also said that he is not certain whether Mićo Stanišić was introduced at the meeting as the future minister of the MUP of Republika Srpska or as the person who was already the minister. So even in this case, in our view, the contents of the testimony is misrepresented and misquoted. In paragraph 613 of the prosecution's final brief, it is claimed that the barricades set up on the 1st of March were apparently an attempt to disrupt the pending referendum. Let me just mention one fact here. I thought that it was not in dispute, because taking into account the exhibits in this case, the referendum was held as early as on the 29th of February. Therefore, the claim that the barricades were an attempt to disrupt it are unfounded. After all, we have heard what the reasons were, and this is all contained in the exhibits. I mean, the reasons for setting up the barricades. And just to mention this for the sake of interpreters, I will now move on to page 50.
Tvrdnja nadalje u tužiočevom podnesku je da je
Another claim in the prosecution final brief is that Stanišić communicated and coordinated with the Serbian political leaders. These are paragraphs 627 through to 637. Paragraph 629, the reference given for this claim about alleged communication is an alleged intercept. However, once this document is analyzed, one can see that this is a transcript made by someone who took notes for a while, noting what the persons engaged in the conversation said, and then the person noting it all provides his own comments and then continues quoting what the interlocutors originally said. Inter alia, it is evident from the contents that Mićo Stanišić complained because Mr. Koljević, who was a member of the presidency, interfered, or rather publicly said something that was confidential in connection with an investigation that was conducted by the ministry. Your Honors, it is normal, I believe, and cannot be considered an element of the JCE or anything similar if the Minister of the Interior is called by the Prime Minister or members of the Presidency. It is a fact that at the time Stanišić holds an official position and he cannot in any way avoid being called by someone. The further claim that he was connected with paramilitaries with a reference to the testimony of one of the witnesses is once again erroneous if you take into account the totality of this witness's testimony. Namely, the witness confirmed that he received this information from General Mladić and that therefore he had no direct knowledge. We deal with this issue in our brief in paragraphs 334 through to 350. Answering to prosecution questions, the witness then claimed that Mićo Stanišić gave him carte blanche to take legal measures against all paramilitaries and arrest them. Asked specifically about Arkan, the witness insisted that Mićo Stanišić had never told him not to arrest Arkan or anyone else, and that he would have done this with pleasure if he had had the chance. This is on transcript pages 13625 and 13626. After all, Your Honors, there is even not a single piece of evidence that Arkan was present in Sarajevo in 1992 in the first place. For the needs of interpreters, I will now move to page 53. The claims contained in the prosecution final brief in paragraphs 646 through to 648, I believe that Stanišić made it possible to facilitate the establishment and operation of detention facilities where non-Serb detainees were mistreated and killed. We deal with this issue in paragraphs 511 through to 516 of our final brief. As for the claim that Stanišić was aware of and supported the role of the police in establishing and operating detention facilities at which non-Serbs were held, which is contained in the prosecution final brief, paragraphs 649 through to 660.
Ja ću prokomentarisati.
I will just comment on this. I already said that we deal with this issue in specific paragraphs of our final brief. I have given you the reference. But the claim contained in paragraph 650, once again, in our view, represents a misinterpretation of evidence. There is again a reference to an intercept, and we already noted our position with regard to intercepts and their value. However, the prosecution claims based on the transcript of the intercept cannot be accepted, as they are a product of the prosecution's selective interpretation. Namely, from the transcript of the document P1115, we cannot conclude with certainty what the word fine refers to in either instance which the prosecution quotes. Namely, the word fine can be a mere speech filler without any actual meaning or a confirmation that he can hear his interlocutor rather than an expression of his approval. After all, Your Honors, when I reviewed the document, believe me, I established that a reply consisting of the word fine is repeated 24 times throughout this document, including contexts which certainly could not denote approval, because they refer to the incursion of Muslim units and so on and so forth. Let me use this occasion to make a comment. The greatest problem with such evidence is precisely that the meaning can be this or that, and neither of the participants in this conversation testified, providing the actual context of the conversation and what the answers refer to, which leaves room for speculation and for different interpretations. In the defense view, this is impermissible, and this is why in our final brief and during the defense case, in principle, we did not rely on intercepts. After all, during his interview with the prosecution, the OTP did not confront Mićo Stanišić with these intercepts in order to establish the context of this conversation and ask for an explanation of the contents. I will now move on to page 56. The claim related to the same topic, which is contained in paragraph 654, that clearly the RS MUP was aware that civilians were detained, is once again an erroneous conclusion. Namely, the prosecution claims in this paragraph of its final brief that the awareness followed the collegium meeting held on the 11th of July 1992 in Belgrade, which the defense does not dispute. However, the prosecution still claims that such an awareness existed even earlier, that the RS MUP was aware of all these things, and then they link that with instructions, which are Exhibit P568. Which allegedly confirms such a conclusion of the prosecution. Later on in its final brief, the prosecution does say that the instruction is of a general nature and insufficient. However, it is a fact that the witness, who is the author of this document, explained in detail the context and the reasons for sending such an instruction. He explained that the reminder of the application of the rules of the international law of war and the strict observation of the law was caused precisely by the existence of an armed conflict in the territory, and that he had no information about detained civilians at the moment. Therefore, once again, the conclusion which the prosecution has drawn is not founded on evidence. The paragraphs of our final brief in which we deal with this issue are 394 through to 396.
Dalje se tvrdi da je
Further on, it is claimed that Stanišić aided in the government's cover-up of the detention facilities. The relevant paragraphs of our final brief dealing with this issue are 511 through to 517. The prosecution claim in 664 that allegedly these orders failed to provide details on how the police were to implement these orders or verify that they complied with them. As a result, non-Serb civilians continued to be held and mistreated, is really completely erroneous. Namely, as we explain in our final brief, and as I will touch on later during my closing arguments, such a conclusion is completely wrong. As far as this issue is concerned, please review the documents 1D 563, 1D 55, 1D 56, and 1D 57. On the basis of these exhibits, and of course the testimony of witnesses, you will conclude that once he learned about this, Stanišić requested that in all instances when the police detained persons, they should be immediately released and granted freedom of movement. That the police should immediately stop securing POW camps and collection centers and leave it to the military, because the army was in charge of that. In accordance with that, as we can see from all these exhibits, Mićo Stanišić ordered that an investigation be conducted, collection of evidence, and filing of criminal reports. Let me remind you that in one of these documents,
to je 1D 57.
1D 57, I hope you can have a look at it. 1D 57. Says the following: the name of the place where the detention camp Mićo Stanišić, that is to say the RS MUP, requests the following: regardless of jurisdiction, it is necessary that you provide the following data. Under 1, the name of the place. Under 2, who ordered that the institution in question be established and when. Under 3, who gave the order for people to be brought to these detention camps, collection centers, and prisons. Then the number of imprisoned people and the number of persons arrested. I think that this sufficiently tells us what Mićo Stanišić was aware of and what the position of the MUP of Republika Srpska about this issue was. Further on, the prosecution claim that Stanišić failed to take adequate measures to protect the non-Serb population and ensure that crimes committed against them were investigated and prosecuted. Is something that we deal with in paragraphs 378 through to 380, 388 through to 393, and 664 through to 670 of our final brief. So, due to the short time at my disposal, let me not repeat our arguments now. The prosecution claim made in paragraphs 671 through to 675 that Stanišić had the duty to act is something that we deal with in paragraphs 231 through to 245 and 394 through to 408 of our final brief. However, let me comment on this, and specifically paragraph 675 of the prosecution final brief, in which they claim that there is an obligation to ensure that a transfer of prisoners of war to another agent will not diminish the protection the prisoners are entitled to. The prosecution claims that Stanišić was responsible regardless of whether the investment of responsibility was made through a legislative enactment or a superior order, or as a result of him finding himself with de facto custody over the detainees. This claim from paragraph 675 is linked also with paragraphs 690 and 664 of the prosecution final brief.
Za ovakav stav tužilaštvo da...
For this position, the prosecution refers to the Mrkšić appeal judgment. However, Your Honors, this reference to the Mrkšić appeal judgment is firstly a completely erroneous interpretation of the judgment. Firstly, the facts in the Mrkšić case are completely different, namely the accused to whom this section of the appeal judgment refers was on the site and present while the TO members were mistreating the victims. It is therefore evident that he was aware of the possible consequences of transferring prisoners to such a group, and the trial chamber was well aware of this. That was why it found him guilty and sentenced him, which of course is not the case here, because Stanišić was very far removed. As for this conclusion from the Mrkšić appeal judgment, which the prosecution refers to, the appeal chamber, in paragraph 71 of the appeal judgment, I have to place it into the appropriate context because the prosecution fails to do so. The appeal judgment, therefore, in paragraph 71 of the appeal judgment recalls that both the TO and the JNA were agents within one and the same command structure, under the command of the Supreme Defense Council, which is not the case here, because the police was not that. Therefore, this position of the appeals chamber evidently relates to agents within one and the same command structure. Further, this position relates to the obligation of one agent to ensure that when transferring prisoners to another agent will not diminish the rights that the prisoners are entitled to. In other words, the agent must be aware that the agent receiving the prisoners will observe the rights guaranteed to prisoners. In contrast to the Ovčara case, where the military police delivered prisoners of war to a group in which, as the court established, anarchy and violence reigned, which did not have clear command structure within the unit. In this case, police handed over the prisoners to the only organ and agent of the state authorized by law, i.e., the Army of Republika Srpska, which, as the police knows, pays special attention in its rules to the protection of prisoners of war. In addition to this, it is not disputed that at the moment the MUP of Republika Srpska was aware of the instructions of the Supreme Commander and the Ministry of Defense about strict observation of the international humanitarian law and specific Geneva Conventions. It is also especially important that regulations, and I mean the law on military courts, gives jurisdiction over POWs only to military judiciary. As for the detainees who do not have the status of POWs but who have been arrested, they are transferred to the Ministry of Justice, which, according to the law, is in charge of holding and detaining prisoners in official penal and correctional facilities and prisons, the operation of which is strictly regulated by the rules, just like the obligations and responsibilities with regard to prisoners. Therefore, in this instance, even if we consider that there is an obligation to ensure that the rights guaranteed to prisoners will be observed by other agents, and I mean the military and the Ministry of Justice, this request has absolutely been met. Further, the prosecution claims in paragraphs 676 and 683 that Stanišić had the ability to act. The defense position about these issues is expressed in paragraphs 381 through to 387, 416 through to 427, and 583 through to 594 of our final brief. In paragraph 681 of its final brief, the prosecution makes a claim which is again erroneous. Namely, the prosecution here claims that Mićo Stanišić that a lack of expert staff in the police was the result of his own doing, meaning Mićo Stanišić, and that this problem that the MUP of Republika Srpska had was a problem of their own doing. However, once again, this claim is unfounded. The evidence shows and we give references in the paragraphs which I already mentioned, that Stanišić requested that absolutely everyone should stay and decide voluntarily whether they would remain in the Republika Srpska MUP or not. Let me remind you of a document which is dated the 1st of April 1992, and these are the minutes from the Collegium which deal with this, the agreement which was reached at the Collegium of the Bosnia and Herzegovina MUP, precisely with regard to these issues. Further, the obligations which are defined by law, such as the obligation to take the solemn oath, certainly cannot be changed by a minister's decision. This is also true about the official insignia of the Republic, such as the flag or the insignia. Really, objectively speaking, this is all outside the minister's power. In paragraph 684, there is again an evident error or a misinterpretation of evidence. In any case, the result is a misquotation in the prosecution footnote 2417, in which it is claimed that Exhibit P190 dates from November 1992, though it actually bears the date the 19th of July. I will return to this document later on, and then I will show this to you. The prosecution claim made in paragraphs 692 through to 696 of their final brief, namely that Stanišić focused his resources on combating looting of state property of Republika Srpska. This is something that we deal with in our final brief in paragraphs 207 through to 222 and paragraphs 231 through to 245. As the trial chamber is well aware of, as this has been established during the case, the Ministry of the Interior deals with all forms of crime, and that is its duty according to the law. Once again, this is a characteristic instance of interpretation by the prosecution, where they interpret evidence outside of any context. Namely, Republika Srpska was established, but clearly its fiscal organs did not exist, nor was a financial system in existence. Therefore, the state had no income from taxes or similar levies, and it was at war. There was no economic production in Republika Srpska at the time because of the war. The only thing that existed were the factories and the big enterprises which needed to be preserved. It is completely normal that a state has an interest to protect its property of great value, such as the TAS factory and several thousand cars. Document P239 deals with that, and the Deputy Prime Minister, Mr. Trbojević, also testified about this. He even said that for this reason the government established a commission to deal with such issues. Exhibit 1D98 is Đerić's letter, that is to say the letter of the Prime Minister, addressed to Mr. Kljajić, in which he requests information about looting of state property. Considering the totality of evidence and the fact that in many evidence presented before the trial chamber, it is stated that the priority in the police work were war crimes, the prosecution claimed that Stanišić focused on combating looting of state property is evidently wrong. Mr. Mačar, who was a witness, testified that the police work cannot be measured by the time spent on a specific case. After all, as you will see later on, Stanišić's letter to Đerić, which is P190, does not talk about TAS or other instances of the looting of property, but only about war crimes. As for the claim that Stanišić focused his resources on documenting and investigating war crimes against Serbs, which the prosecution deals with in paragraphs 697 through to 702 of its final brief. I will give you a reference because the defense explains its arguments in detail in paragraphs 409 through to 415 of our final brief.
U odnosu na Stanišićevu akciju,
As for Stanisić's action against the Yellow Wasps, which the prosecution references in paragraphs 703 to 712 of their final brief, and which the defense addresses in paragraphs 351 to 365 of our final brief, the totality of the evidence presented at trial in relation to this action is completely disregarded and ignored. In the course of their closing arguments yesterday, the prosecution addressed this issue, and specifically at pages 62 to 63 of the transcript, Mr. Olmsted followed up on what Mr. Hannis had to say on this issue the day before, i.e. that witness Mačar was not a credible witness, in other words, a defense witness. Interestingly enough, there was another witness, witness Andan, who testified to this issue, and there were a number of prosecution witnesses who testified the same way witness Mačar did. However, their credibility is not raised. Further, the prosecution quote Exhibit P403, and they say that the issues of war crimes were not raised, only of looting. But evidently the prosecution forget P1539, a prosecution exhibit, and it is a record of the statement made in relation to war crimes. After all, the fact of the matter is, Your Honours, that brothers Vučković were indicted and convicted of war crimes as a result of a report and documentation gathered in the course of this particular investigation. The fact that they were convicted in Serbia and they are nationals of Serbia only speaks about the fact that the justice administration, the judiciary, did not function in Republika Serbia, in Republika Srpska, which is something that the defense have advanced as their position throughout, and something that Mr. Stanišić himself spoke of in the course of 1992. As for the allegations made at paragraphs 709 and 710, about the alleged reasons behind the action against the Yellow Wasps, I think that witness ST179 clearly explained his positions and dilemmas on this issue, on the issue of the related incidents. After all, the evidence demonstrates that Stanišić had been preparing the action against the Yellow Wasps for some time. You will recall that Žugić of the National Security Service was charged by Stanišić as early as in May to start collecting information and evidence related to the Yellow Wasps. Furthermore, the prosecution fully disregard the evidence that the special police unit, together with the detachment of the federal SUP, went to Brčko before going to Zvornik to deal with the paramilitaries there. We have Mićo Ilić and Andan and many other witnesses testifying to that effect. After Brčko, they went to Bijeljina on the same business. They clashed with Chetnik units, with Mauser. And at that point, they went to Zvornik. They were supposed to go to Foča and Višegrad, but for the reasons known to the trial chamber that were told by witness Andan, they were unable to do so because Serbia would not allow them to transit their territory. At the end of the year, that same special unit went to Trebinje, Gacko, Rudo, and Čajniče, in other words, the southwestern part of Bosnia and Herzegovina, on that same business, namely to arrest, prevent the activities of, and prosecute these paramilitary units. When it comes to the responsibility under other forms of responsibility, under other forms of liability, rather, that the prosecution address in their brief, starting from paragraph 809, I will say this briefly because we deal with the topic in paragraphs 625 to 663 of our final brief. At paragraph 809, the prosecution say only that the prosecution proved that Mićo Stanišić instigated crimes. The fact of the matter is that instigation is not only addressed, but it isn't even mentioned in any of the other paragraphs of the final brief. Therefore, this conclusion, as was the case with many other prosecution conclusions, do not relate to facts to all intents and purposes. When it comes to aiding and abetting, as I said, the issue was addressed in our paragraphs between 652 and 663, so I will not repeat that. Under the issue of superior responsibility, we explained our position in paragraphs 671 to 686 of our final brief. I would like to say a few words about this issue. For interpreters, it's page 67, where the prosecution say that the accused had effective control over their subordinates. They substantiate their claim with the following statements: that the accused exercised administrative authority over a highly organized and hierarchical police forces. The position of the defense on this issue is contained at paragraphs 529 to 537 of our final brief. The other assertion made by the prosecution on effective control says that the accused had strict control over information. The position of the defense on this issue was explained in detail in paragraphs 261 to 278 and 279 to 284 of our final brief. The defense brief provides a detailed analysis of the quality of the existing communications as well as the amount and quality of information reaching the RS MUP. The assertion made by the prosecution that the system of informing and reporting was satisfactory and operational is simply hard to believe in view of the totality of evidence which speak to the contrary. Can you please look at slide 5 now? It's a graph that we made on the basis of the testimonies of witnesses Page and Kezunovic, as well as based on exhibits P625 and 1D338. I believe that the graph clearly shows what the situation was in the relevant period, objectively speaking. The accused had the authority to undertake criminal and disciplinary procedures against subordinates. This assertion was made at paragraphs 850 to 862. Now, the position of the defense is expounded at paragraphs 538 to 563 of our defense brief. I have to stay with this issue for a while. Give me a moment, please.
Hvala, časni sud, izvinjavam se.
Thank you, Your Honor. It is beyond dispute that it is the duty of a superior to take necessary and appropriate measures within his power. That would, by the very nature of things, include the initiation of a criminal procedure if the instant case includes criminal responsibility. However, when it comes to superior responsibility within the Ministry of the Interior, the situation is quite specific. Such an authority to undertake a criminal investigation or a criminal procedure is vested with all the authorized officials of the Ministry of the Interior who are duty-bound under the law to initiate a procedure as soon as they learn of the perpetration of a crime. This is something that we address in paragraphs 381 to 387 of our final brief. Therefore, this duty, possibility, or authority to file criminal reports, which arises from the law, has no cause and effect relationship with their command position or any other post within the hierarchy of the ministry. Since such an authority is vested with a rather large number of individuals, as I say, regardless of their position within the hierarchy, in my view, the question that the case law will have to give an answer to is whether this authority can, in this sense, be considered to be an authority strictly related to superior responsibility or not, of course, within the context of the Ministry of the Interior. On the other hand, in view of the fact that there is a wide circle of individuals who are vested with the same authority, and in view of the obligation that exists under the law, that in every single case they have to exercise this authority and initiate a criminal investigation, the question is, does a minister have any reasonable basis on which he should doubt that the subordinates within the ministry, authorized officials, are using and exercising this authority in view of the imperative obligation that they have under the law? And I mean these authorized officials. I believe that there is foundation in the position whereby it can be reasonably presumed, or rather that the minister can reasonably presume that his subordinates are exercising this authority because they are duty-bound to do so under the law. In that context, the prosecution position comes as a surprise to the defense, or rather their suggestion, because they seem to suggest that it is the Minister of the Interior who should be the one to file criminal reports. And that would indeed, in my view, be excessive in view of the context of the entire situation. Therefore, it is our position that the only thing that can come under command responsibility, and that would be strictly in keeping with the law on internal affairs, is the authority to undertake disciplinary procedures and not the authority to undertake a criminal procedure. The assertion made at paragraph 852 of the prosecution final brief, where it is stated that even where a policeman voluntarily resigned from the police on account of a serious disciplinary offense, he was still subject to disciplinary procedure. This is one of the examples that I drew your attention to at the very start of my submissions today. The prosecution references this assertion with witness Rodić, that's transcript T8902 to 8903. However, shortly before the answer quoted here by the prosecution, this is what Mr. Olmsted asked the witness, and I'll quote it so it'll be in English.
You discussed a couple of issues with regard to about the police officer who resigns during the process of disciplinary proceedings, and therefore the disciplinary proceedings are cancelled. Do you recall that at the beginning of the session? Yes. Dakle,
therefore, not only does the prosecution in this particular case quote a portion of the testimony that would lead to an erroneous conclusion, but also by the very nature of things, the conclusion is pointless. Your Honours, it is not possible to carry out a single disciplinary measure envisaged by the law unless the individual in question is an employee of the police. This because all these disciplinary measures relate to and arise from the individual's employment, such as pay cuts, transfers to a different post, or, as the severest measure under the law, termination of employment with the police. Therefore, if where a procedure is initiated against an individual, the individual voluntarily resigns from the police, what sense would it make to initiate a procedure? It would be moot and a waste of time and resources, because the outcome that could be the result of such a procedure has already been achieved through his departure from service. In relation to the positions stated in the prosecution final brief at paragraphs 863 to 870, which relate to the assertion that the crisis staffs did not diminish the effective control that the accused had, I wish to state that the defense addressed these issues at paragraphs 595 to 613. The assertion made at 867 reads, the appointments made by the crisis staffs were considered to be the proposals on which the RS-MUP considered when making a final determination, and in our view, it amounts to the misinterpretation of evidence. The evidence confirms that the local organs were the ones who made appointments within the Ministry of the Interior, regardless of what the positions of the Ministry of the Interior of Republika Srpska were. They were made completely without the knowledge of the RS-MUP, and in some cases, the chiefs that had been appointed by the RS-MUP were replaced. You can read more about that in our brief. I do not wish to reiterate our positions, but I do ask their honours to read the relevant paragraphs. The last topic before our break will be the assertion that the army of Republika Srpska did not diminish the effective control of the accused. The prosecution addressed the matter at paragraphs 871 to 880 of their final brief, and the defense presented their positions at paragraphs 223 to 230 of our final brief. The most interesting issue here that I would like to mention in my arguments is the issue of the existence of a parallel chain of command, as indicated by the prosecution at paragraph 639 of the final brief. That's where they mention the issue for the first time. Such a parallel system of command is, in my view, key to proving the existence of other independent authorities who had effective control over RSMUP members. In other words, in support of a position that is the opposite of what the prosecution contend. Your Honours, if we accept that there is a strict hierarchical structure within the MUP of Republika Srpska, as the prosecution claim, and if the MUP was indeed the way the prosecution claimed it was, that's to say a part of a criminal plan, why would it be necessary in that case to form a parallel structure within that same alleged plan as indicated by the prosecution? Why would that be necessary? If you have a MUP which is part of a common criminal plan, and there is a common chain of command, and the prosecution claimed that this sort of MUP is a part of a criminal plan, why would that criminal plan also include a parallel structure? What would be the rationale? What would be the reason for something like that? Your Honours, it is our position that the MUP was not a member of the joint criminal enterprise as a hierarchical structure. According to the evidence, there is an explicit request that the government sent to the crisis staffs in its instructions that they should not interfere with the command and control of the army units. And despite such an instruction, the crisis staffs were indeed in command of the police and the army. This is not in dispute. However, this means that in each and every one of these cases, the prosecution had the duty and obligation to prove beyond a reasonable doubt which of the two or more order-issuing authorities of the SJB or RSMUP members were indeed being obeyed, whose orders were they carrying out, who were they held answerable to, and who did they report to. The evidence adduced at trial, in my view, are evident in that sense. Unfortunately, the priority was indeed with the local authorities, and we did raise this issue more than once in our brief and today. Yesterday, at pages 68 and 69 of the transcript, the prosecution said, in relation to the principle of the unity of command, where they cited the Struger judgment, the paragraph 367, something that is obviously misplaced and inapplicable to this situation. However, since it is likely that some of these issues will be discussed on Friday, I will not be spending time on it. All the factors that are familiar to the jurisprudence and which point to the absence of effective control, this is something we discuss at paragraphs 677 of our brief, have been proven beyond doubt in this case. The totality of evidence shows that, without a doubt, there were independent authorities who had, without any doubt, effective control over specific RS-MUP members. These organs made appointments and replacements of certain individuals, paid them and gave them orders. In return, these individuals carried out their orders, reported to these organs, and carried out their decisions and regulations. Such organs issued decisions appointing chiefs and even lower-level leaders of public security stations or security services centers. These organs were the ones who changed the territorial jurisdiction of the MUP of Republika Srpska as envisaged by the law. This was in the case of Teslić, the decisions of the crisis staff and the municipality to join the ARK Krajina. At times, they would directly change the functional organization of the MUP of Republika Srpska by subordinating security services centers to the authority of public security stations, as happened in the case of Doboj. All these events, without a doubt, happened independently of the MUP of Republika Srpska and without its knowledge. The evidence shows beyond doubt that some of these RS-MUP members clearly perceived local authorities as their bosses rather than the RS-MUP, as was the case with Drljača. This is something witnesses testified to during the instructive visit, and this is supported by a number of other exhibits in this case. Or the case of Todorović, where the chief of the CSB received threats from the president of the Bosanski Šamac crisis staff, serious threats, when the former asked for his removal. There are many other such examples, and you can find them in the defense brief. There is a category of individuals who had never become members of the MUP. There was an absence of effective control in that case in view of the explicit legal regulations. All these categories of individuals did not obey the orders or instructions of the accused. Furthermore, we cited on several occasions during trial examples which show that it is true that members of the RS-MUP, at the point where they become resubordinated, lose the capacity of authorized officials. Whilst they are under the command of a military commander, they cannot exercise the powers vested in them by law, because they would highly likely not fall within the scope of the task given to that unit, such as, for instance, manning a firing position or similar. Therefore, to exercise their powers would be contrary to the order issued by the military commander. On the other hand, if we were to accept the position of the prosecution, failure to exercise such powers would constitute under the law a breach of duty. I suppose, Your Honours, that it is obvious that the theory advanced by the prosecution is completely untenable. I also wish to say that it was proven beyond doubt that all the witnesses who had leading positions in the RS MUP agree with what I've just said, with the position I've just relayed. They did not consider themselves as superiors to the policemen who were resubordinated. As for the reporting from the subordinates to the accused, the totality of evidence shows that this reporting and informing was not only insufficient in terms of the amount of information available, but the quality of information was unacceptably low, especially in the first 6 months. There is a considerable number of orders and instructions that the RSMUP was issuing to the lower organs through to the end of 1992. We still have on our screens the graph that I showed you a moment ago. Your Honours, I do think that this is the crucial argument where it comes to the issue of communication. I assert that the issue and the problem of communication was sufficiently addressed and substantiated with the evidence in this case, and indicates the permanent nature of this problem that prevailed throughout 1992. Your Honours, I suggest that we take the break now, as I am about to move to a different topic. Thank you.
So we return at 2:20.
All right, we will